Welcome, welcome to the Chalala Weekly webinar. And it's September 8th. Thank you all for joining. For the people who are new and for the people who have been joining us every week. We really appreciate your support and hope to find that today we've got a chock full of great updates. We're going to talk a little bit about some immigration updates, and then we're going to get right down to our downgrade series, getting in preparation for October 1st, where hopefully a lot of you will be able to adjust either through your original application or through downgrading. So either way, this is going to be some useful information to help you with your immigration journey. And so I'm going to give folks a few minutes to join. I was trying to find a way to. Kara, if you could, I think you've got to enable captioning. I think that's sometimes helpful when people are watching. So if you can enable that, that would be great. And then we can get started. I hope you all had a very safe Memorial Day weekend. And who can see the transcript? Okay, good. The transcript is basically so that if I talk too fast, or you will not only get a chance to hear me, but you get a chance to see what I'm saying, in case I say it too fast. So let's get started. September 8th, 2021. The USCIS extends the evidence of status for conditional permanent residency. Previously, the receipt notices can be used to show evidence for up to 18 months. Remember, that's if you're a conditional resident and you have applied to remove the conditions. The receipt notice was only valid for 18 months. Now they've increased it to 24 months with pending 751 or pending 829. So that's 751s if you're a conditional resident pursuant to a marriage-based petition, and 829 if you're conditional resident pursuant to an EB-5 application. So you've got an additional 24 months. And then the OFLC offers guidance for those who are affected by Ida, Hurricane Ida. So extensions for deadlines in terms of audits, responses to notices of deficiency, recruitment reports, business verification, sponsorship documents, supervised recruitment, request for reconsideration of a PWD. If the deadline is between August 29th and November 29th, it will be considered timely if received by November 29th. It's only applicable to the employers affected by Ida. So let's say you have a deadline. So what that means is, let's say you have a deadline September 1st. Then you have until November 29th. So anytime, any deadlines between August 29th, any deadlines in between August 29th and November 29th, as long as it's received by November 29th, it'll be deemed timely. And remember, this only is for those impacted by Hurricane Ida. And short-term placement guidance, they note that short-term placement guidance and what constitutes a material change is also been outlined, because they know that people are displaced because of the hurricane. So let's get down to our downgrade series. What should I do? Everyone wants some sort of magical solution as to, here's my priority date. Should I downgrade? I've got an EB-2. What will the movement be? Does it make sense to get a downgrade? Should I just keep my application as is? So, really there's no clear formula as to this. And there are people that can give you predictions, but there are a lot of things that impact the visa bulletin, as we've talked about. So if I were you and I could have two paths, so you have a plan A and a plan B, because this is such an important thing, then I would go ahead and do it. how you do it is going to be based on a lot of things. So that's why the series is so important, because there's a lot of considerations you have to put in place before you decide whether you should do a downgrade, whether it makes sense. And then, there are a lot of people that ask, should I filed last October, should I wait for my I-140 to get approved, or can I go ahead and do this now? You don't. There is no requirement that you have to wait for your I-140 to get approved. Now, let's just talk about the whole issue of, I've got a pending I-140, what can I do? Okay, these are for the people who filed maybe last year, not as a downgrade, but as a regular adjustment with their EB-2, and or they filed with their EB-3, and they're trying to look at what are some other solutions. Number one, there's a lot of talk about interfiling. In order to interfile, your underlying I-140 has got to be approved. So if that's not approved, you can't simply do an interfile if you've got both an EB-2 and an EB-3. So what can those people do? If you like, you can file a second adjustment. There is no bar for filing a second adjustment of status. There is only a restriction that you can adjust. You can get the benefit of a green card with one. So what does that mean? That means that at some point the USCIS is going to say, hey, you've got two adjustment applications. Tell us which one you want to use, and then you can withdraw. So you are eligible if you've got a pending I-140 and a 485, but your I-140 is not approved. You can either file another adjustment if you've got another, if you've got an EB-2 approved petition or an EB-3, another EB employment-based category approval notice, in addition to the one that you use for your adjustment. If you do not, you can either downgrade or upgrade and file a new adjustment of status application when the dates of filing are coming out, if you are eligible. So this is strategies for those people who already have filed an I-140 last year, and an adjustment. Now, the second question is, okay, I didn't file last year. I want to file this year. I want to file a downgrade. And so should I amend or file a new I-140 petition? There was a lot of confusion about this last year. Now, we recommend filing a new petition. The rule is when your perm is certified, in order for that perm to have life and not wither away and die, is if the I-140 is filed within 180 days of the perm certification. Any I-140. So that doesn't mean that you can't use that perm for other purposes. In fact, the regulations state, unless it's fraud or unless the I-140 was, the perm was approved erroneously, you can use that perm to file a subsequent I-140. And they outline certain conditions, like if there's a successor in interest, you must amend. So there must be an amendment filed if you're a successor in interest. That means if a company has acquired your company that went through the perm process and you filed an I-140, you've got to file a successor in interest amended. If for some reason the I-140 was denied, and it can be denied for a number of reasons that have nothing to do with the validity. Maybe the person that put it together didn't, have all the documentation. Maybe you were pressed and didn't understand what the requirements were. There could be a number of reasons where it's an approvable I-140, but it was denied or revoked for a number of reasons. So, and then you can file, and historically the USCIS accepted it. We did it, I think last year people were kind of concerned because it has been a long time before this type of opportunity presented itself. So you can file a new I-140. And what that does is it gives you the benefit of your previous I-140 and then an approval notice in a new category. And you can file that concurrently with an adjustment of status if you fall under the dates of filing for October or November. So when you file a concurrent new I-140 for a previously approved perm application, remember, you're not filing the I-140 with the original perm, right? No original perm. So you can't file under premium. You have to file under regular processing. Moreover, you can't file an I-140 and adjustment of status at the same time under premium. So you file initially regular. So you would file your new I-140, and then you would file the adjustment of status along with it under regular processing. And then in about a 6-month time, you can try to upgrade that I-140 to premium processing. Now, what are some things you should consider when you are downgrading and filing a new I-140? Remember, anytime you file an I-140, you always have to prove the eligibility of that, of seeking that classification. What do I mean by that? A lot of people think, okay, I filed an EB-2 a long time ago, it was approved. I don't need to demonstrate all those things all over again with this application, with this petition. You're wrong. Every time you file an I-140, there are 2 things you've got to demonstrate. Number 1, that you had the education and experience prior to joining your employer, unless you fall under specific exceptions. And we will go over that, those very minute issues within the series, but that is overarching number 1, what you have to demonstrate. Number 2, you have to demonstrate that the employer has had the ability to pay from the time the perm was filed until now. The regulations state until you get your permanent residence, but practically speaking, it's only at the I-140 where all of this is tested. So this is really important if you're thinking of filing an I-140 for your employer that you're not currently working with. You know, like I said, we're going to go into details of this in our, series down the road. So one of the things we're going to talk about at length is ability to pay. Generally speaking, the 3 ways to demonstrate ability to pay. The net income on the employer's tax return. The employee has been paid the salary stated on the perm, or the net current assets. Now, so the employer has to demonstrate that they had the ability to pay using one of these 3 evidentiary items from the time the perm was filed until this I-140 is being filed. This could be years, because if it was a previous employer, it could be years since that has taken place. Now, remember, the employer has to demonstrate that for every year, right? And they can do that in a combination of the 3 things I outlined. The employee was paid the salary, the employer's net income, and the employer's net current assets. Okay, so the net current assets are outlined in the balance sheet on the tax return. The net income, of course, is probably more self-evident. And you can use a combination. Let's say, for example, you were making the prevailing wage on the perm was $50,000, and you were making $30,000. You're $20,000 short, but the net income for the company was $20,000. You can use that to demonstrate ability to pay. So every year there may be a different analysis that's put into place. So that's probably one of the topics we'll touch upon next week, because it's pretty important. So take a look at that to get more detail. But I just wanted to make sure that you understood from an issue that if you're not currently working for that employer, and you have not been, that you can only demonstrate ability to pay within 2 ways during the period you are not working for that employer. You can no longer use your salary. So that's just one of the things that you want to confirm, go over. I know We did that. A lot of employers were not comfortable sharing that information with their previous employees, so they would send the information to us, and we would look through and confirm whether we saw that there would be an issue or not. So that's one of the things that you have to be cognizant of. There's also issues of the Child Protection Act, and we'll have a webinar where I'll just talk about the Child Protection Act, but there's some strategies that are available, whether it's through these EB program, or as I talked about earlier, through the investment, the EB-5 investment program, where you're going to get, because processing time is a little bit longer, you'll get more of the years your child's age will be frozen. But we'll talk about some of the considerations and some of the rules and limitations of that and what you have to keep in mind. It's not carte blanche that you get. It's not for every situation will you get that protection. There's certain criteria that have to be met. So we will be addressing that also. In terms of retrogression, you know, at least Charlie from the Department of State has said he doesn't expect any till at least the first half of the fiscal year next year. Usually when there's a retrogression, it takes place in the third quarter. That's where I'm thinking that we may see a retrogression unless Congress acts or does something in the interim. And remember that even if, let's say a lot of people are worried about the risk. What's the risk if I downgrade and it's denied? Well, as long as there was no fraud and misrepresentation, once an I-140 is approved, that priority date is vested with you. It's your priority date, no matter if you try different processes. So, and each one of these is reviewed de novo. I mean, so it's a denial on one is not, unless it's fraud or misrepresentation, is not necessarily going to impact your previously approved I-140. And so that's good to know. The risk, I don't believe, is that high. What I would suggest that you do, because we're already in September, can you believe how this year has passed? I can remember when we were talking about it, and it seemed like October was so far away. But, you know, the dates are coming up, and whoever you're working with, whoever your attorney is, what I would say is try to gather the documentation as early as you can and get it to them. It's not that we haven't done last minute filings. I just don't like them. We've got, you know, things can happen. All of a sudden, you know, computer systems start doing crazy things because they're overworked. Anything that's online is usually impacted during this time. And we like to have a redundancy of review. One person reviews it and somebody else reviews it to make sure that everything, all the I's are dotted and T's are crossed. And then there's a final review before it goes out on things that will keep the file from being rejected, like checks, making sure they're made out correctly, the amount on the check is correct, they are all signed. All these are things that could cause your application to be rejected. And if that window of opportunity closes, you have no recourse. So all the forms need to be signed. All the forms need to be attached. All the correct checks, as I stated, need to be in place. And so you want to make sure you have that time frame. So don't wait till the last minute. If you're thinking of doing this, you got to jump in sometimes. You just got to have faith and say, I'm going to do this and I want to do it right. So I'm going to do it as soon as I possibly can so we can get all the documentation in. But that is pretty much it for today in terms of our update. Join us next week when we will talk about ability to pay and some nuances relating to that issue. And so if Shaker Chella is ready to join us, Please post your questions in the Q&A and not in the chat. He can start moderating the questions. Hi, Shaker.
Hi, how are you?
Good, good.
Looking good.
Thank you.
All right, let's see. Good afternoon, everybody. As usual, I request you post the questions in the Q&A box and any response that the attorney is seeking when she's answering your question. Appreciate you put that in the chat. Just make things easy. All right, first one is from an anonymous attendee. I want to go for stamping first time after STEM OPT. Looks like all visa offices are closed. Do you have any idea any visa offices open for stamping for Indians?
Well, I know that they were putting on priority stamping for at least F1s, but you may want to consider going to Mexico. We've got a link I'm sure we'll share. There's a gentleman that assists students getting stamping, even if it's for the first time, in Mexico. And we had a webinar on that. And he even talked about how certain Mexican consulates are more friendly than others. But I think that may be a good option too. And this company, they will, meet you when you get there, help you get your visa to Mexico, take you to the interview. So it's kind of a full service. And they're very familiar with the various US consulates in Mexico. So they know which ones are good for, especially first time F1 processing.
All right. Next question. And these are all anonymous attendees. Whenever I see a name, I will, say the name. Next one, I-485 transferred from NBC to Texas Mesquite. Applied in March 2021 and my priority date, May 16, 2010, EB-2. Will it delay my process as case transferred?
Yeah, we all know that Texas is as slow as molasses, and the transfer time can take anywhere from, in normal circumstances, would take 6 to 8 weeks. I would suspect that right now we're not in normal circumstances. They're short-staffed, so it may delay it even longer.
All right. Next one, is there any travel ban for green card holders to go to India?
Not that US citizens and green card holders should not be subject to the travel ban, but Kara can send a link on our most updated issues on travel ban. Remember last week we talked about how Europe is going to implement, the US is now on the unsafe list. I haven't checked this week if India has put us on the unsafe list, but that's a separate issue from the visa processing issues. But Kara will post that up in the chat conversation.
All right. Next one is another anonymous attendee. Lakshmi Garu, thanks a million for your support. My priority date is August 2011, downgrade. I-140 approved under PP, medical supplied along with 485, but did not get biometrics appointment till now. So my question is, if I don't get biometrics appointment before September 30th, then what is my situation? When can I get biometrics appointment in GC? I'm worried a lot because next year India will get only 1, 3, and 2, 5, 10,000 GC visa as per my understanding.
Right. Remember, you're already in the process. So, and you're so far along that I would see if you can request to get your biometrics done earlier. There are ways you can contact USCIS. And I know that with a lot of our applications, we are saying, hey, we're worried about, they're current right now. This particular application is current. So trying to get them to prioritize those applications. So we had a webinar on what you're supposed to do to try to contact the USCIS. I would suggest that you take a look at that and keep contacting them. The greasy wheel, the greasy wheel. And Shaker, just 1 second, I wanted to share something with our folks. It is I wanted to remind people, can you see the screen? I did a screen.
Just see the Telegram regular screen.
Huh?
Just see your presentation with the Telegram QR code.
Okay, yes. I think it's because I'm using 2 screens that it's doing that, but that's okay.
Just push it to the main screen. Probably should do it.
No, it's not letting me do that.
Or if you are in a full screen mode, maybe you exit from full screen mode and then, or go back and share that document, because you probably are only sharing this document instead of sharing your entire laptop screen. So if you were to originally share, the left topmost window, which is blue, that is your entire laptop, then you can share any application. But if you're sharing just this application, then you have to go back and unshare and share the other one.
Okay, well, I'm just going to do it this way.
Okay.
Let me see if I can do view. Okay. Okay, so we're just going to do it this way. For those of you who have not joined our Telegram group, we've got a Telegram group, Clarity for Hum, and I think probably sometime in the next few days, maybe I'll even do it on the weekend, I'm going to have a Cella chat with the Telegram group. I do that every so often to answer questions. It's just you and me and the rest of our friends on this community that is going through pretty much the same thing that you're going through. And in terms of immigration, everyone is so helpful with sharing information and things of that sort. It's really a great community to be a part of. And if you want to join, all you have to do is open up your phone to the camera and get the QR code in the center, and the link should come up. Or you can copy the link at the bottom and join through that mechanism. So, yep, the link is coming up. So this is our group. Like I said, it's a great group. We post updates, answer questions, and it's a good organization to be a part of, and you feel the kinship with other people who are going through exactly what you're going through. Remember, we have our weekly webinar. So if you haven't registered for our webinar, please register. And again, if you're registered, maybe you can get the link by putting up your phone to the, get the QR code, and then forward this link to your friends. Because the next few weeks are going to be really chock full of great information on how to navigate October 1st. So please join us, but share that with your friends. And if you can't do the QR code, there's a link at the bottom. And finally, because we've been doing YouTube Live, there have been no PowerPoint presentations with our weekly webinar. So whatever topics I'm talking about, I'm going to do snippet videos of that and post that on our YouTube channel. And remember, again, your camera, you go up, you subscribe, because if you're not subscribed, you won't know when a new video has been uploaded. So I greatly appreciate if you would do that. Share that with your friends and let them know that there'll be information on there. I've got family all over India, some of whom are going through this process themselves, that are working at some of the most prestigious organizations that have a lot to do with what we're doing today, you know? So, and even though they're at such a, you know, a highly successful company, they're not getting the information from their attorney. So they call me and they say, well, what can we do? And so I tell them, you should do this, you should do this, you should do this. So they go back to their attorney and they say, hey, I heard I can file both an EB-2 and EB-3 at one time. And the attorney goes, yes, you can. And our relative will say, well, why didn't you tell me that beforehand? And their response is, you didn't ask. So here is a way in which that you can find out what questions to ask to make sure you facilitate your journey. So like I said, if you're on a computer, then you can do it so simply by putting your camera up and not only registering yourself, but sharing the information with your friends. So thank you so much. And I can now go back to stop share. There we go. We're back again.
Yeah, I wanted to just acknowledge an email that came last week about a YouTube user saying, you know, it's a limitation in terms of how many letters, words, characters they can use. Just like Twitter, I think there's a limitation on asking questions. So they wanted to know if we can provide, you know, some information or something about how they can submit questions on YouTube while they're watching our program on YouTube. And I think I responded saying we'll be in touch, but I apologize if we haven't sent it, but I think we'll
look into that and make sure we let you know.
Yeah, because we'd like to make sure that you have a good experience, you know.
And you can always email us at info@cellolaw.com.
Yeah, you can always do that. But I think when they're listening to the program live, they want to ask questions, and there's a limitation, so you know you can't really put, you know, anyway. So, gentlemen, ladies, whoever that was, we'll get you the information. So I'm going to start again. So next question is from Pratik. Pratik says, need help to understand if I-485J is approved, but PD date is not current. Is it good to change employer and any risk with it? My PD is December 2014, EB-3 straight.
Well, Pratik, welcome. And the issue is not whether your I-45J was approved or not, or anything else. Remember, AC-21 portability, 3 things. I-140 has got to be approved. I-485 has got to be pending for 180 days. And then you change to same or similar employment. So if those 3 things are true, then you can change employers without it impacting your permanent residence process. You will have to submit a new I-45J with your new employer. There are some people that say, let's wait for the RFE. I'm of the mindset that I would rather send that in because some people are being approved without an interview. So why have an RFE, which can delay the process? Those are my thoughts.
All right. Next one is from Abir Singhal. Abir, how are you? Abir says, hi, Lakshmi. Does it make sense to nudge USCIS for EB-1C I-140 pending application as the category is current, or just wait for them to process? Thank you, and Shekhar, for keeping up with these webinars.
Well, thank you, Abir. I hope you and your family are doing well. Thank you for joining us. I would say, you know, it never hurts to nudge Emma or contact the USCIS and just say it's current now. I'm concerned about, you know, it's been pending for a very long time. And maybe even outline how, you know, because you have, you know, in your instance, you know, instituted a tremendous investment in expanding to the US. I think that's a great way to kind of make sure that they understand the importance of what you're doing and how you've been in this limbo state for a very long time because your I-140 backlogs. It cannot hurt your application. So I would do that without any hesitation.
All right. Next one is from Ram. DS-260 applicants from India. What is the way to submit the civil documents to NVC? By post or scan upload? Now I see scan upload button is not available after submitting DS-260 online. My category is EB-1, current.
You can try to, it may be because you already submitted the application that the scan document is missing. What you may want to do is try to, you get the NVC number, right? Reference number. Email it to them with the reference number and just send those documents to them that way to see if they will attach it to the file. If they do not, they'll always request it again, but in order to avert the delay, that may be the best way to get the information to them.
As a computer person, I would suggest whenever something is not working, if you've logged out, log in again. If that's not the case, log out of all your applications, restart your computer, log in again. You never know. That's my 2 cents on that.
Thank you for your 2 cents.
Okay, next one is from an anonymous attendee. While changing job from employer B to C, which I-140 to use? Employer A1 I-140 approved back in 2013. Employee B, current EB-2 and EB-3 I-140 separately approved in March 2021. Used EB-3 I-140 for current AOS 485 application in process. Employer C, willing to transfer my H1, which I-140 I should use and how much H1 duration I will get for employer C.
Right, so that's a very good question.
Yeah.
Because remember for AC-21 extension of your H-1B, the crazy thing is, remember, you can only get the extension if your I-140 is approved and you don't have a valid priority date. Now, the problem is it's taking so long to process the I-485s and people want to have a safety net. We've been submitting them in certain cases where people are really concerned, and we state very clearly that even though the date is current, number one, you guys are processing them at a very slow rate. So this person does not want to have any issues with their continued work authorization. Because when you file for an H-1B extension, even if it's filed regular, you've got the 240-day rule where you can continue working for the employer. And with EADs taking so long, that could be problematic. And there could be a lapse in employment authorization. Now, in terms of what I-140 to use when you are shifting to a new employer, remember, in order for portability, AC-21 portability, I-140's got to be approved. You've got several I-140s, that's fine. The I-485 that supports that I-140 has to be pending for 180 days. So you've got to use the I-140 that you used in support of your adjustment application, so you don't have to go through the process again, right? So you need to use the I-140 that supports the AOS application you filed. And as long as it's been pending 180 days and you're working for same or similar employment, you can port to your new employer C.
All right. Ram is back. He's asking, for this question, I could see both options in internet case. I think that's the guy who's had trouble. Which one is the latest procedure, online or offline submitting documents, civil documents?
I know that we have used both, but I can check to see if there has been something recent in that. That is what my team works on, and it's such a minutia area that how to upload the documents is not something I'm always, I know what we've done, but there may be something that's different now. So if you email us, Ram, at info@cellolaw.com, I'll check with my colleagues and let you know what they have experienced.
All right. I don't see any open questions on the Q&A box, and the chat is also, there's nothing there.
Good. Well, I want to thank everyone for joining us today. Next week, we're going to talk about what are some hurdles in the I-140, any updates, whether it's congressional updates, what's going on with Congress, and or any updates on immigration. And, you know, like I said, continuing our series on best practices for downgrading your I-140. So share this with your friends and make sure you attend. And, you know, because when people send me questions and we've gone over it in such great detail in our webinars, I just wish they would take their lunchtime and attend the webinar so they could get a much more detailed explanation. Now, teamwork makes the dream work. It's not, I'm not the only one that puts all this together. I've got a great team and a great set of resources that I truly depend on. Shaker and I are the face of this webinar. It's a lot of people that put in a lot of hard work. Anyone that's on our Telegram group or email info@cellolaw.com knows the name Kara Wood. She does a great amount to make sure the information gets out to everyone. And so I always like to make sure that we appreciate her wonderful work that she does to help facilitate all of this. You all have a fabulous week, and I'll see you again next week. And maybe, like I said, if you join our Telegram group, maybe I can see you this weekend in doing a one-on-one group discussion. So take care.
All right. Thank you all. See you next week, and thank you, Lakshmi, for the
Bye-bye.
opportunity. See you soon. Bye.
Thanks, Harshareddy.
Yeah.
Shout out.
Thank you, Lakshmi Garu and Shaker. Thank you, Harsha. Take care.